Stop. Don't claim your Social Security yet. 6 words that should completely reshape how you approach your retirement planning. And if you're over 55, or if you're supporting someone who is, what I'm about to walk you through over the next several minutes could be the difference between retiring with confidence and spending your later years dealing with financial pressure you never anticipated. Earlier this week, the Supreme Court delivered a landmark decision on Social Security that virtually every major news outlet completely overlooked. While journalists were busy covering interest rate speculation and entertainment headlines, one of the most significant legal rulings in recent memory was quietly published in the Federal Register. And here's what genuinely concerns me about that silence. The people who need this information most urgently, those on the verge of filing for benefits, those already collecting them, are completely unaware. They're moving forward with decisions that could cost them enormous sums of money without realizing that something fundamental has just shifted beneath them. I've dedicated the past 18 years to studying Social Security legislation, retirement income strategy, and government benefit planning. I've guided thousands of households through these systems, and I can say with complete confidence that the vast majority of people are making their most consequential retirement choices based on information that is either incomplete or simply no longer accurate. That changes right now in this video. 3 words. That's all the Supreme Court required to fundamentally redefine how the Social Security system calculates your benefits, how it handles spousal claims, and how it treats the contributions you've made throughout your working life. Those 3 words are about to open claiming strategies that were previously unavailable, close loopholes that were draining retirees of hundreds of thousands of dollars, and fundamentally alter the way you should approach when to file, how much to claim, and who in your household should file first. If you're someone who insists on having the complete picture before making life-altering financial choices, go ahead and hit that like button right now, because what I'm about to share is the direct opposite of the oversimplified content flooding social media feeds. This is real, thorough analysis. This is what genuinely matters. Before I reveal those 3 words and unpack what they mean for your situation, I need to provide some essential context. Without understanding the background, those 3 words will feel meaningless. More importantly, you won't grasp how to apply this information to protect your household's financial well-being. Social Security operates on a framework of rules. Rules governing when you're permitted to file, rules determining how much you can earn before your benefits are reduced, rules concerning spousal and survivor benefits, and rules outlining how the system calculates your primary insurance amount. For decades, these rules have been interpreted in ways that helped certain individuals while placing others at a disadvantage. For just as long, advocates, retirement specialists, and legal professionals have argued that certain interpretations didn't align with what the Social Security Act actually says. The Supreme Court rarely intervenes in Social Security matters. The system typically operates through administrative law judges, federal appeals courts, and the Social Security Administration's internal review process. But when lower courts begin reaching conflicting conclusions about what the law means, when genuine disagreement arises over a foundational principle, that's precisely the moment the Supreme Court chooses to step in. That's exactly what occurred here. This case began 5 years ago. A woman, we'll refer to her as Margaret, submitted a benefits claim at age 62. She had spent her entire adult life working and had contributed to Social Security for 43 years. She was entitled to a monthly benefit of roughly $2,200. But Margaret was married. Her husband had accumulated slightly higher benefits across his career, approximately $2,300 per month. Margaret's intention was to claim her own benefit at 62, accept the reduced payment because she needed the income, and then later collect a spousal excess benefit once she reached her full retirement age. This approach is commonly known as restricted claiming, and it was once a recognized legal strategy. The Social Security Administration rejected her request. Their position was that when you file for your own benefit at any age, you've implicitly filed for every benefit you qualify for, including spousal benefits, and because you filed early, every one of those benefits is permanently reduced. Margaret's legal representative argued that the actual statutory language doesn't support that interpretation. The law, they contended, draws a clear distinction between your primary insurance amount and excess spousal benefits. The law provides the option to restrict your filing to your own benefit alone and leave other benefit types untouched. The SSA had essentially invented a rule that doesn't appear anywhere in the legislation. This case traveled through the federal court system, and in March of this year, the Supreme Court sided with Margaret's attorney. The court's ruling stated that the Social Security Administration had been applying an overly broad interpretation of the statute. The law makes clear distinctions between different categories of benefits. You retain the ability to make different decisions about each category. You are not forced into an all-or-nothing outcome. Those three words that changed everything. Benefits are separate. That's the ruling in its simplest form. The Supreme Court declared that benefits are separate. Your personal retirement benefit is distinct from spousal benefits. Spousal benefits are distinct from survivor benefits. Government pension offsets are evaluated independently. And this matters profoundly because it unlocks claiming approaches that were previously unavailable while closing exploitations that had been costing retirees significant sums. Let me walk you through specific examples of what this ruling actually means in practice. Picture a married couple, both 62 years old, both eligible for retirement benefits. Under the previous interpretation, filing at 62 meant accepting a permanently reduced version of everything you were entitled to receive. Your retirement benefit was reduced for early filing. Your spousal benefit was reduced for early filing. That was the entirety of your options. You received one combined reduced figure. Under the new Supreme Court ruling, these are treated as entirely separate decisions. You may now be able to file for your own retirement benefit at 62, with the early filing reduction applied only to that specific benefit, while delaying your spousal benefit claim to a future date. Your spousal benefit is no longer automatically penalized simply because you filed for your own retirement benefit ahead of schedule. You get to make that decision separately, potentially at a different age and under different circumstances. I want to be absolutely transparent about something important right now. This ruling does not mean the Social Security Administration will be reaching out to offer you additional money. It does not mean that everyone can immediately take advantage of new strategies. The Supreme Court's decision applies to specific circumstances, but for those whose situations fall within its scope, the implications are substantial. Here's who this ruling affects most directly. If you're married and your spouse's lifetime earnings are considerably higher than yours, this is directly relevant. If you postpone Social Security while your spouse filed early, this is relevant. If you're weighing filing before your full retirement age while your spouse considers delaying, this is relevant. If you're a surviving spouse trying to understand how survivor benefits interact with your own retirement benefit, this is relevant. The single most important takeaway is that benefits being separate means you have more choices available than you previously realized. In certain cases, you have considerably more flexibility over when and how you file. In some situations, you can structure your household's overall benefit package in ways that meaningfully increase your lifetime income. In other circumstances, you can preserve survivor benefits for your spouse in ways that weren't previously accessible. But here's the critical point that trips up most people. The mere existence of an option to claim benefits separately doesn't automatically mean you should exercise that option. Determining the right structure for your household's Social Security benefits ranks among the most consequential financial decisions you'll face in retirement. Make the wrong call and you could surrender hundreds of thousands of dollars in lifetime income. Make the right call and you could secure your spouse's financial stability long after you're gone. The Supreme Court ruling creates new possibilities, but possibilities only deliver results when you know they exist and understand precisely how to use them. That's what the next portion of this video addresses. I'm going to take you through exactly how this ruling plays out across different real-world scenarios, what questions you need to honestly ask yourself, and what concrete steps you should take immediately to ensure you're not surrendering money you've rightfully earned. This is the most significant Social Security information you're likely to encounter in years. Stay with me. Let's begin with the most common scenario. You're married. Both of you are nearing retirement. One of you has substantially higher lifetime earnings. Say the higher earner would receive $2,800 per month at full retirement age. The lower earner would receive $1,800 per month at full retirement age. Before this Supreme Court ruling, your options felt confined. Either you both filed early and accepted permanent reductions, or you both waited and tried to work out who should delay and who shouldn't. But the math always felt restricted. Now, because benefits are separate, You have access to approaches that simply didn't exist before. The higher earner could file for their own retirement benefit at full retirement age, collect the full $2,800, and defer any spousal benefit claim to a later point. The lower earner could file at 62 or 63, collect an early benefit from their own work record, and subsequently file for a spousal excess benefit once the household's total income is properly optimized. This combination was not available under the previous interpretation. Under the former rules, filing at 62 permanently reduced everything you were eligible to receive. Under the current ruling, filing at 62 applies a reduction only to that specific benefit, leaving other benefit types as independent future decisions. Why does this matter so much? Because in certain situations, this kind of structure can increase a household's lifetime benefits by $50,000, $75,000, or even over $100,000. That's not an exaggeration. The numbers accumulate across decades. An increase of just a few $100s per month compounds into tens of thousands of dollars across a 20-year retirement. Let me now walk you through a more layered scenario because the ruling's implications deepen the closer you examine it. You're a widow or widower. Your spouse passed away at age 74 while receiving $2,600 per month in Social Security. You're currently 58. You're entitled to survivor benefits based on your spouse's earnings record. The full survivor benefit at your full retirement age would be roughly $1,900 per month. But you need income now. You're tempted to file for survivor benefits immediately, even knowing you'll receive a reduced amount for claiming early. Before this ruling, filing for survivor benefits at 58 meant a permanent reduction. You were locked in. You couldn't later file for your own retirement benefit as a separate decision. You couldn't make distinct choices about different benefit categories. Everything was bundled together and reduced simultaneously. Under the new ruling, because benefits are separate, you may be able to claim survivor benefits now at 58, accept the reduction on that specific benefit only, and then at 62 file for your own retirement benefit separately, with different reduction factors applied to that benefit alone. Or you might choose to delay survivor benefits, file for your own retirement benefit early, and then collect survivor benefits later with a smaller reduction applied. The essential point is that you now have separate decisions to evaluate rather than a single forced outcome. This matters enormously for widows and widowers because survivor benefits can sometimes exceed your own retirement benefit, and the interaction between these two benefit categories can generate meaningful advantages when you understand how to structure them properly. Let me present another scenario that directly touches the lives of millions. You're 64 years old. You've worked throughout your entire life. You'd receive approximately $2,200 at full retirement age. Your spouse is 62 with lower lifetime earnings, projected to receive $1,400 at full retirement age. Your spouse is considering filing now because the household needs income, but you're concerned that an early filing might somehow reduce your own benefits or lock both of you into less favorable long-term outcomes. Before this ruling, some of that concern was legitimate. If your spouse claimed at 62, the administration would have treated that as an implicit claim for spousal benefits on your record as well, which would have triggered reductions and complicated your household's overall benefit structure in ways that were difficult to untangle. Under the current ruling, your spouse can file for their own retirement benefit at 62, without that automatically triggering a claim for spousal benefits based on your record. Those remain entirely separate decisions. Your spouse accepts a reduction on their own benefit for filing early, but that does not automatically compromise the spousal excess benefit decision down the line. You and your spouse can each make independent, thoughtfully timed choices about when and what to claim. This flexibility can be genuinely powerful. Here's what I need you to absorb from all of these scenarios. The Supreme Court ruling doesn't guarantee that any particular strategy is the right one for your household. What it does is widen the range of available strategies. It removes artificial restrictions that the Social Security Administration's earlier interpretation had imposed. Now you must actually think carefully about what's optimal for your specific household rather than defaulting to a single predetermined path. This is exactly where most people stumble. They learn that new options exist, they get excited about the potential, They rush to file without fully understanding the consequences, and then several months down the road, they realize they've made an irreversible choice that cost them an enormous amount of money. So let me be completely straightforward about what you need to do beginning right now. First, determine whether this Supreme Court ruling actually applies to your circumstances. Not every household benefits from the new flexibility. Some situations are straightforward enough that the old approach and the new approach lead to the same optimal outcome. You need to establish clearly whether you're in a situation where the ruling genuinely creates new opportunities or whether it doesn't meaningfully change your household's best course of action. Second, gather precise information about your household's specific benefit amounts. You need to know exactly what your own retirement benefit would be at 62, at full retirement age, and at 70. You need those same figures for your spouse. You need to know what spousal benefits you'd be eligible for and in what amount. You need to know what survivor benefits would be available to your spouse if something happened to you. Informed decisions cannot be built on rough estimates and guesswork. Third, recognize that how Social Security interacts with other elements of your retirement income matters considerably. If you receive a pension, how does it intersect with Social Security? If you carry substantial investment income, how does that influence the tax treatment of your benefits? These specifics are important because they alter the calculations around timing and claiming amounts. Fourth, and this point is essential, approach these decisions as a household unit if you're married. A strategy that appears individually optimal for you may actually undermine your spouse's long-term financial security. If you were to pass away, your spouse would receive survivor benefits shaped by the choices you made. You need to factor that in. You need to coordinate. You need to consider your spouse's financial well-being after you're no longer here, not only your own immediate income needs. Here's your action plan starting today. Log into your Social Security account at ssa.gov. If you haven't created one yet, do it now. The process takes roughly 15 minutes and costs nothing. Review your complete earnings history. Examine your estimated benefit amounts at each potential claiming age. Download your statements, print them, and keep them accessible. These numbers need to be in front of you when making decisions. Next, if you're married, sit down together with your spouse and have this discussion as a team. Social Security decisions should never be made in isolation. Walk through various scenarios together. Address what happens to your spouse if something happens to you. Discuss income needs in the near term and later in retirement. Make sure you're both aligned before taking action. Third, give serious consideration to working with a financial planner or Social Security specialist who understands what this Supreme Court ruling means in practice. Yes, that involves cost, but a qualified advisor working through your household's specific benefit picture can realistically identify hundreds of thousands of dollars in additional lifetime income through strategic claiming decisions. The advisory fee pays for itself many times over. Even more critically, a good advisor helps you avoid making irreversible errors that cannot be undone. If engaging an advisor isn't financially feasible, free resources are available to you. The Social Security Administration provides benefit calculators on its website. Nonprofit organizations offer free counseling on Social Security matters. But regardless of the path you choose, please do not make significant filing decisions without conducting a thorough analysis first. The stakes are simply too high. You've invested an entire working life to earn these benefits. You deserve to collect every dollar you're entitled to receive. There's one more thing I need to address because it matters. While the Supreme Court ruling creates genuine new opportunities, it also introduces additional complexity. The Social Security Administration is still working through how to implement this ruling internally. There will be situations where local field office representatives aren't fully current on the updated rules. There will be circumstances where the administration's systems haven't yet been updated to reflect the court's decision. You might contact Social Security, inquire about a specific claiming strategy, and be told it isn't possible when the new ruling clearly makes it available to you. If that happens, don't simply accept that answer. Ask to escalate to a supervisor. Reference the Supreme Court ruling directly in your conversation. Ask them to identify the specific regulation or statute they're relying on to deny your request. Document every interaction carefully. If you believe you're being denied something you have a legal right to receive, you have the right to formally appeal that decision. In complex situations, Having an attorney or a benefits advocate in your corner can make a decisive difference in the outcome. This is precisely where the Supreme Court's 3 words carry real power. Benefits are separate. That straightforward principle should give you a sense of empowerment. It should give you confidence that genuine options exist. It should motivate you to dig in and truly understand what those options are for your specific situation. In the coming weeks and months, the Social Security Administration will be releasing additional guidance. Federal courts will be hearing cases that test the boundaries of the ruling's application. New information will emerge, but the foundational principle has now been firmly and permanently established. Benefits are separate. You hold more control over your claiming decisions than you previously understood. Thank you sincerely for watching this video. If you found this information valuable, please take a moment to share it with someone you care about, a parent, a sibling, a close friend, anyone approaching retirement who deserves to understand how this ruling affects their future. Subscribe to this channel so you receive updates as this story continues to develop, because the full impact of this ruling is still unfolding. You earned these benefits through decades of hard work. You deserve to understand them completely, and you deserve to make decisions that genuinely protect your financial security and your family's future.